Very good morning, ladies and gentlemen. Respected Honorable Director General ADCOC, Mr. Uday Bhaskar, the President ADCOC, Dr. Jayanta Chowdhury, and the Chairperson of the today's webinar, Dr. Dharmadatta ji, and the guest speaker, Mr. Nilesh Gandhi ji, and all the executive and central council members of ADCOC and the regulators, both at the central and state drug control departments and industry and academia. A warm welcome you all for the 29th edition of the ADCOC Training Academy. And it's really a great honor and privilege for me to have the senior officers and the office bearers of ADCOC on a regular basis for imparting the training and knowledge to the members of the ADCOC. And I'm really privileged to have today on with us Dr. Dharmadatta sir and Nilesh Gandhi ji, who are strong pillars for the formation of ADCOC and strengthening of the ADCOC across the country. And we are so pleased to have you with us, sir, on the today's session. And today we are going to talk on the drug price control order, the price monitoring of the drugs in the country, in the country. As we all know that the affordability and accessibility of the medicines is the prime focus for the healthcare policies in the world, not only any country, but across the world. And to ensure the equitable access, the affordability of the medicines is one of the prime focus to ensure the equitable access to the population. And with that motto in mind, so every healthcare policy makers work towards ensuring the medicines, and even in the country, the drug price control order is in place to ensure the equitable access and affordability of the medicines to the population. However, in the current times of the pandemic, whether this objective of the equitable healthcare access is available to the population or not is a matter of question. Especially when the essential medicines have been monitored by the agencies, the definition of the very essential medicines have been changing, especially in the current times of the pandemic, in a rapid way. So in this current times, how could the government, the agencies are working in that direction? And in the today's session, let's hear more insights from the guest speaker. And before that, let me invite Dr. Dharmadatta sir, who is the retired former director for the Drug Control Administration of Andhra Pradesh. And he is very strong pillar of the ADCOC formation, and he served at various roles. And he served as a vice president for ADCOC and editor for the ADCOC newsletter. And also he is a founding member of the state association of the drugs inspectors of Drug Control Administration Andhra Pradesh, and he also served as a vice president. Dr. Dharmadatta sir holds a PhD degree and a law graduate also, and I have had the fortune of working under him in my earlier days of Drug Control Administration. So pleased to have you with us, sir, and I welcome you for introductory remarks.
Just a moment, Lakshmi. He is also the recipient of Best Drug Control Officers Award in 2008.
Sorry, sir, I missed to mention. Yeah, please.
Very well. Thank you very much, Lakshmi Prasanna, for giving a lucid introduction about me and adding a vital point about ADCOC in connection to me by the Uday Bhaskar about Best Drug Control Officer Award. And at the outset, my dear drug regulatory officers in the country, well-wishers and friends, good morning to all on this fine, very fine morning. On hearing about this, that I'm called for the panelist of this today's session, I'm very happy to note that I can once again, after a long gap, I can see our own loving professionals that are drug regulatory people through this virtual platform. This virtual platform has created a very good image for the ADCOC mission, actually, in fulfilling the ADCOC's mission. In this connection, you see the COVID-19 pandemic has brought so much has actually caused so much of havoc to the people in the entire world. Apart from that, it has given a good lessons or positive lessons to the humanity also, but especially for the AIDCOC organization, because it has actually made us to fulfill our mission, AIDCOC's mission, very effectively, very fast and fruitful way. We know that when we call about these training programs and training academy about AIDCOC, I recall my olden days. That is the birth of the AIDCOC. That is the 28th December 1995 at Visakhapatnam. I still remember when the IPC was going on. The Uday Bhaskar and this, they gave me an opportunity to announce on the stage that all the drug control officers should assemble at one place to form the organization. That was the starting point. So since then this thinking is happening. I think this year is the 28th year of formation of the 27th year of formation of the AIDCOC. And there are actually the COVID-19 period, if you take 2 years, if you just make it as a hibernation period, actually this is the silver jubilee of the AIDCOC, actually formation of the AIDCOC. So we have to, though these virtual meetings are very effective and going on well, we can plan for the silver jubilee function also on this by leaving those two. That we have to. I will appeal to the organizers. That also is very, very important. So from the beginning, this AIDCOC is facing so many hurdles to form, But anyway, because of the dynamic leadership of the Deshpande and Uday Bhaskar, and at that time there were so many others also, it was made possible, and it is effectively functioning today. For any association, the great leaders say 3 points to be followed to run successfully. One is that in critical things, there should be a unity. In important things, diversity. And general thing, always it is a generosity. These 3 points our organization is following. Important thing, the critical things, it is unity. Important things, diversity. And this in always it is generosity. These 3 points are seen in the various activities. Whenever you talk about anything about the qualifications and the DCJ or drug inspectors, whatever it may, we are unanimously very strongly fighting. That is the unity. Diversity, when you discuss a legal point or anything, the different diverse opinions always will put in the WhatsApp, etc. That is the very required thing. From that, we'll get the final approved point of those discussion. Similarly, in generosity, always this AIDCOC is showing a lot of generosity. When you award the Neha's award, we have instituted, and Kerala fund, flood fund, we have generally done. Wherever there is a compensate post, etc., we are always ahead. That really with a great difficult thing, we made it possible because of this leadership qualities. Our leaders are continuously been imparting in this organization. So with this background and all, I will once again tell that AIDCOC is a very, very important thing. Our mission is that if you see our mission when it was formed in the 1995, immediately we have formed the mission and the bylaws, etc. in the Hyderabad meetings. If you see the mission of this AIDCOC, the keywords are this training. First word is the training. Second one is the coordination. Third word is the actually important keyword is that you have to becoming a part of the healthcare system. These 3 points will be there in the mission. The first point is the training, because training is very important for the especially drug inspectors and the other licensing authorities to discharge their duties very effectively to serve the people in supplying safe, efficacious, and affordable drugs to the community. So in that mission, because of this COVID, we are already going in very fast direction. I think already 20 months over by starting this training program. It is going on well, and I thank organizers for giving this opportunity actually to interact with this platform. And we have a lot of, I think, eminent personalities are giving lectures and workshops through this platform. And today we have Nilesh Gandhi, very talented person, very knowledgeable person, and his lecture definitely inspire many people in controlling the prices of the drugs. That is why I congratulate and thank Nilesh Gandhi, and I wish him all the best to deliver his effective lecture. Thank you, Lakshmi Prasanna. We'll proceed to the further. Thank you very much.
Thank you so much, sir. And you have rightly named important leadership qualities that are very much inculcated in the Adcock leadership team. All three qualities of generosity, diversity, and unity. And Adcock is meant for all these three qualities. Thank you so much for your encouraging words. So, ladies and gentlemen, now moving on to the main talk of today's webinar on the drug price control mechanism by our beloved speaker, Sri Nilesh Gandhiji. And I'm sure all the members of Adcock are very close to Nilesh Gandhiji, but as a protocol demands, it's my duty to brief about the profile of Nilesh Gandhiji. So, Mr. Nilesh Gandhi is a graduate in pharma and postgraduate in law, and he started his career with the industry, in the pharma industry, and later he joined the FDA Maharashtra as a drugs inspector and served over there for about 2.5 decades in different wings, in the inspections and the intelligence and several other wings at different places. During his tenure, he is so instrumental in detecting the cases of the spurious, adulterated, and NSQs, and also he was at the forefront of the FDA's initiative, especially in the projects of the software development for the WHO GMP certifications or this licensing system for the sales and manufacturing. For his contribution to the department or the public health, he was awarded with many awards, and he was recipient of the Best Drugs Inspector Award by the All India Drugs Control Officers Confederation. And he was also a recipient of the Best FDA Person of the Year in 2007 by 54th IPC Trust in Pune. And after 2.5 decades of experience in the department, Sri Nilesh Gandhiji has taken a voluntary retirement, and he associated with Sri S.W. Deshpandeji, and he is working with in Pharma Lex and offering the complete legal solutions and also the technical and professional services for the industry and the pharma fraternity. And I'm so proud to mention that Nilesh Gandhiji, along with Sri Deshpandeji, has co-authored an exhaustive commentary on the Drugs and Cosmetics Act 1940 and rules, including the medical devices rules and the NDCT rules and the cosmetic rules and the DMRO Act rules and DPCO. So the 10th edition of the publication is extensively useful for all the regulators and even the manufacturers and the advocates and the academicians and the entire pharma fraternity. And I could say that this is the book of standard for all the entire pharma fraternity in the country. We are so much pleased to have you with us, sir, on the today's session. And I must say that he is the active member and the important pillar of strength for the Adcock and strengthening of the Adcock in the state of FDA and also in other places. And he is also on board as an expert CGMP training for the manufacturers for access to the quality assured medical products organized by the WHO in association with IPA and JSS Academy of Education and Research in Mysore. So we are pleased to have you with us, sir, and I hand over the stage for your insightful presentation on the DPCO.
Thank you, Lakshmi. So I'll just share my presentation. So good morning, all. Hope everybody are in good state of health, and there are many stalwarts which are in this panel as well as the participants. So I'll try to justify the subject which have been given. And there are, I know that I'm aware that many of the officers and the office bearers and industry are experts in this DPCO. If anything is you want to add, or any thing which may differ, you may contribute to it. So with this, I would like to start my presentation, and let us have that. What are the general perceptions and myths about DPCO? Although there are experts, they must be clear about this. But generally, in the average people, what are the perceptions about drug price? Are that drug price in India is a major hurdle for industry to growth or availability of the good quality medicine, and such price control is not existing in any other country. So this is what is the general perception. Prices of non-scheduled drugs are out of purview of DPCO, and they are not monitored. So only scheduled drugs are monitored or price controlled. Small scale industry enjoys the exemption from the price control. The DPCO 2013 do not value the indigenous innovations like patents, product patents or process patents. Therefore, it discourages the R&D. This is what I am talking about, the general discussions or myths which people have about DPCO. The price list, which is to be issued in Form 5, is only meant for scheduled formulation or formulation under price control. DPCO is not applicable to medical devices and Ayush medicines like Ayurvedic, Siddha, Unani, homeopathic medicine. Making few changes in the strength, dosage form, or ingredients in the scheduled formulations would leave you out of scope of DPCO. Therefore, you can manipulate the formulation and go out of purview of scheduled formulation, and you can enjoy or quote whatever price you want. NPPA cannot fix the price of non-scheduled formulation. So this is what a general perception myths general people have. So with this background, let us see what is the facts. What are the facts? We'll go into detail and we'll see what are the provisions under the DPCO. First, we will see whether such or any kind of price control exists worldwide or globally. What are the trends to make available the affordable medicines to the citizens of that country? So almost price control mechanism exists in majority of countries, except you can specifically say that US doesn't have any kind of price control. However, different approaches are followed in other countries, such as external or internal reference prices. Means there would be a reference to the prices, which may be external or internal devised, and there might be index pricing or cost plus pricing, then market-based pricing, or pricing by negotiation. So these are different approaches which are followed by different countries. So you will see UK regulates return on capital and sales, not return on investment. On whatever the capital has been invested and sales, UK tries to regulate on the basis of return on that capital and sales. Japan, Ireland, Netherlands, or Norway, Portugal, Spain, Switzerland follow reference pricing. They use some references to control the prices of drugs in their country. New Zealand, Australia operate formulary based pricing. They have a formulary, and those formulations in the formulary are under price control. France, Canada set prices through negotiation. Austria regulates price through legislation. So India is a mix or have different approaches. It doesn't follow a single approach, which is followed by other countries. It is a mix and unique kind of mechanism we'll see henceforth. So let us see to the history. What is the history? Since when this price control is existing? So earlier, when the China aggression was there in a war with China, 1961-62, the Defense of India Act was there. The Essential Commodities Act was not there. I mean, it was there. However, drug was not essential commodity notified under Essential Commodities Act. However, there was need to control the prices, which was due to there was a lot of price increase in the imported and locally manufactured drugs due to disruption in the availability of APIs as well as formulations. So drug price or display of prices order since 1962 and drug control of prices order 1963 was promulgated under Defense of India Act. And thereafter, the drug as a commodity was inserted in the Essential Commodities Act. And then thereafter, the orders, DPCO, drug price control orders, were issued under the Essential Commodities Act. So DPCO 1966, 1970, 1979, 1987, 1995 were promulgated under Essential Commodities Act, and at present drug pricing is governed by DPCO 2013. So first we'll see what are the relevant provisions under Essential Commodities Act 1955. So drug has been notified as an essential commodity under section 2A, that is definition, and there is a schedule to the Essential Commodity Act. Under that schedule, at serial number 1, the drug is placed as essential commodity. Drug price control orders from 66 are issued under section 3 of EC Act, wherein it empowers central government to give or to notify the order so as to control the availability, accessibility, and prices of that particular essential commodity. Any violation of DPCO shall be considered as punishable under section 7 of Essential Commodities Act. So there may or may not be any punishable para under order. Earlier it was there, now it is not there in 2013. But since the order is issued under Essential Commodities Act, any violation would be punishable under section 7 of the Essential Commodities Act, and it provides for punishment of imprisonment for term not less than 3 months and which may extend to 7 years and fine. So this may differ as per the gravity of the offense, which has been mentioned there in section 7. So we will not go much into detail for the punishment part. Then section 10 of Essential Commodities Act says, just like section 32, section 34 of Drugs Act, all partners, directors shall be considered as responsible when, if they are involved in conduct of business of that firm or that company. So they will be considered as liable under section 10 or liable to punishable under section 7 if there is a violation of DPCO 2013. Section 10A says that every offense punishable shall be cognizable. So cognizable has been provided, specified. However, bailability is defined by the schedule under CRPC. So every punishment which is less than 3 years would be considered as bailable. However, the punishment of 3 years and above will be considerable as a non-bailable offense. And section 14 is very peculiar just like what we can say under NDPS, the burden of proof of his innocence lies on the accused. So this is very important. Although we have to establish with proof, however, the burden of proof lies with accused as per section 14 of the Essential Commodities Act. Now we'll see the background of DPCO, how it is evolved, how it is changed, and how the policy changed gradually as per the requirement in that scenario. The National Pharmaceutical Pricing Policy was declared in 2012. It was notified, and object of this policy was to put in place a regulatory framework for pricing of drugs to ensure availability of essential medicine at reasonable price. Why I'm saying this, why I'm bringing to you these objects, because we have to always keep in mind what is the perspective of the DPCO, what are the provisions, and what is the background for making that provision. So we don't have doubt, and our focus remains that what was the objective of the policy based on which the DPCO has come out. So while providing sufficient opportunity for innovation, the competition to support the growth of the industry should be there. So both the opportunity for innovation shall be provided, and competition in the market shall regulate the prices. And meeting the goals of employment and shared economic well-being, this is the general objective. Then what are the key principles of National Pharmaceutical Pricing Policy 2012 is essentiality of drugs linked to National List of Essential Medicines, and which would be a dynamic. So earlier, in 1995 DPCO, there were APIs which were under schedule, and formulation made out of that APIs were regulated. Prices of them were regulated. So consequently, formulation prices were also regulated as per the formula. However, here the formulations or the schedule should be considered only in case of essential medicines. So there would be a national list of essential medicines, and essential of the drug should be linked to pricing. The control of drug formulation prices only. So based on specified API, strength, dosage form, and route of administration. So all these things which define the essentiality, only those formulations should be considered for under price control. Then the key principle should be market-based pricing as opposed to cost-based pricing. So what are the cost of input material or profits should not be basis for price control. However, market-based, what are the prices in the market, and it should be basis that market forces will control the prices. Competition will control the prices. So 5-year exemption for new patent or new drug delivery system developed for the first time anywhere in the world through indigenous R&D shall be protected or shall be exempted from the price control. Then devices notified as drugs are to be covered under DPCO 2013. So we will come to next level now. The National Pharmaceutical Pricing Authority has been established under at the time of DPCO 1995 itself. So the authority, which is independent authority, which enforces the drugs price control order. So it has been established by a government resolution dated 29/8/1997, and it is the key composition of the authority is chairperson would be of the rank of secretary to Government of India, and member secretary of the rank of joint secretary, additional secretary to Government of India, and ex officio members would be DCGI, economic advisor, Department of Economic Affairs, advisor, director cost, and department of expenditure. So these are the key. However, there are many other such members which are invitees or co-opted in the authority so as to evolve, so as to work in accordance with the objective of the policy. And what are the functions of the NPPA? Price fixation, price revision, and other related matters such as updating the list of drugs, inclusion, exclusion on the basis of established criteria and guidelines. So the criteria shall be defined. There would be guidelines for inclusion, exclusion of any drug in the schedule. However, let us be clear that national list of essential medicines is not defined or devised by NPPA. There is a different mechanism to come out with the national list of medicines or update or include the drugs into it. However, the schedule to DPCO will be decided under some criteria and guidelines by NPPA, which will be thereafter included under the DPCO. And it is empowered to take final decision subject to review of Government of India if necessary, to implement and enforce the provisions of Drugs Price Control Order, to deal with all the legal matters arising out of the decisions of the authority, to monitor availability of drugs, identify shortages, and to take remedial steps. So these functions have been already notified, and thereafter, in line with policy, in line with functions of NPPA, the paras or provisions under paras of DPCO are seen. So you must read all together so as to get the holistic view of DPCO. To collect, maintain data on production, exports, and imports, market share of individual companies, profitability of companies. This is also very important. So this is also monitored by NPPA for bulk drugs as well as formulation, to render advice to central government on the changes, revisions of in the drug policy as well. So let us see some of the grave differences under DPCO 95 and DPCO 2013. So under 95, only bulk drug prices were under schedule. However, now NLEM, National List of Essential Medicines, and formulations are under price control and under the schedule. There were 74 APIs earlier. Now there are 815 formulations containing only 47 bulk drugs or APIs from DPCO 1995. So the bulk drugs under price control as compared to 95 list has been reduced. However, if you talk about a 815 formulation, there might be more than 74 APIs. However, they are as a formulation, not as a API, which are under price control. Formulation containing these APIs, all the formulations would be covered under price control under DPCO 1995. However, now only formulation under Schedule 1 and are under price control. Calculations are based on manufacturing cost or input cost under 95. However, now market share based pricing mechanism has been given, and simple average price of all brands with market share above 1% is taken into consideration. Small scale units exempted. Now no such exemption is there. So all the companies, whatsoever, means they may be micro, medium, small, or large scale, formulations manufactured by them would be under price control. No such exemption is there now. Non-scheduled drugs not under price control. There was no price control for non-scheduled drugs under 1995. However, now non-scheduled drugs are also indirectly under monitoring not under ceiling price control. However, the price rise is allowed only up to maximum 10% per year. Product withdrawal was not prohibited. So if the manufacturer felt now it is not possible or viable to continue with the manufacture of drug which is under price control, they were free to withdraw that product. Now there is a price withdrawal mechanism provided. You have to follow that mechanism if you have to discontinue your product or withdraw that product from market. Now we will see the DPCO, various provisions of DPCO. So DPCO 2013 has been notified under Section 3 of EC Act on 15th of May 2013. Just a minute. There are total 32 paras and 2 schedules. So first schedule is the national list of essential medicines. At the time 11 was under schedule 1. It contained 680 formulations and having 348 bulk drugs into this formulation. However, this was amended and NLEM 2015 was notified and it is now part of schedule 1 and it has 376 bulk drugs and 815 formulations are in this national list of essential medicine. So let us come to second schedule. What are the second schedule? Second schedule is there are prescribed forms. Form 1 is pro forma for application for price fixation or revision of a new drug formulation. What is new drug? We will deal it afterward. Related to NLEM formulation. Form 2 is pro forma for submission of revised prices for scheduled formulation. Form 3 is pro forma for quarterly return of production, import and sale of NLEM drug. Form 4 is pro forma for submission of details for discontinuation of production or import of scheduled formulation. So discontinuation is related only with scheduled formulations, not with the non-scheduled formulation. Form 5 is, everybody must be knowing, aware of this, it is pro forma for price list. So we'll come to it afterwards. This pro forma for price list is for both scheduled formulation as well as non-scheduled formulation. So each drug, while selling, while distribution, every manufacturer has to issue the price list in Form 5. And now in 2021, there is a new pro forma, Form 6 has come, and this is exclusive for medical devices. So now we will come to key formulations which are necessary to understand so as to understand all other provisions. So formulation means what? A medicine containing one or more drugs for internal or external use or for in diagnosis, treatment, mitigation, prevention of disease. This is almost parallel to definition of drug under Section 3B of Drugs and Cosmetic Act. However, it doesn't require any notification to be issued. It is simple general definition which includes medicines for internal or external treatment. However, it doesn't say anything whether it is applicable for the human beings or animals. So we can consider it is for both. So Ayurvedic, Siddha, Unani system of medicine, this is exempted. Homeopathic system of medicine is exempted. And where the provisions of Drugs and Cosmetic Act are not applicable, the DPCO, provisions of DPCO will not be applicable to them. Okay. So those medicines or articles or whatever substances which are out of purview of Drugs and Cosmetic Act, then DPCO will, provisions of DPCO or will not be applicable. It will not be covered under the definition of formulation. Now we will come to the definition of manufacturer. Very important definition. Here it includes what any person who manufactures, imports and markets drug for distribution or sale in the country. So manufacturer means importer, manufacturer means marketeer, manufacturer means actual manufacturer. So all of them are covered under the definition of manufacturer. Wholesale price index. So this is nothing but which is declared by DIPP. Now the department's name has been changed. So it is Department for Promotion of Industry and Internal Trade. So each year the WPI is declared, notified in the March, and accordingly the changes are made in the prices. So then new drug, which is very important. This is not as defined under drugs and drug rules or NDCT rules. It is different. The new drug will be considered a formulation launched by existing manufacturer. The existing manufacturer, there is a definition to for existing manufacturer under para 2. I can tell you that existing manufacturer means what? The manufacturer existing on the date of notification of DPCO, that is 15th May 2013. Manufacturer who is existing at that date and of a scheduled formulation, means a scheduled formulation under DPCO 2013. If that manufacturer is manufacturing and marketing that formulation, that manufacturer means importer, marketeer will be considered as existing manufacturer. So formulation launched by existing manufacturer means already who is manufacturing, distributing scheduled formulation. What he does by combining a drug with another drug, either listed or not listed in the schedule, launched by changing the strength, doses or both of same drug specified doses and strength listed in schedule. In short, if the manufacturer tweaks or make changes in the strength or dosage form or route of administration, strength of any scheduled formulation, any ingredient in that scheduled formulation, or if any ingredient, additional ingredient is added to that scheduled formulation or reduced or deleted from that scheduled formulation, all such formulations are introduced, launched by the existing manufacturer, then that drug will be considered as new drug. Clear? So new drug will be any changes in the scheduled formulation, you will have to go through the mechanism of new drug. So that will come to it afterwards. So what formulations are monitored? So scheduled formulations are monitored under price control. Non-scheduled formulations are under price control. Medical devices are under price control. New drugs are. So everything, if you say, which are covered under Drugs and Cosmetic Act, all those formulations, medical devices are under price monitoring. However, APIs, the price are not controlled. However, they are monitored. Only the information of the prices of APIs are collected by NPPA. However, the prices are not notified, or there is no restriction as such in the pricing of API. So para 3 of DPCO, what it says, there is a power to give directions by NPPA. NPPA means central government. So there is a notification in place that the powers which are said to be with the central government, that has been delegated to NPPA. So we can now say that NPPA means central government. So they have a power under para 3 to give directions to achieve adequate availability to regulate the distribution of drug in public interest. So if there is a public interest, which we have seen during the COVID period also, that it may direct the manufacturer of any API. It can also direct to API manufacturer as well as formulation manufacturer to increase the production and sell the API to other manufacturers of the formulation, and to direct formulator to sell the formulation to institutions, hospitals, or any agencies. So this is a vital power with NPPA in case of emergency, in case of inadequacy, in case of shortage of certain drugs. It has power to give directions and make the such drug available in the interest of public health. So now we'll see how the prices of scheduled formulation are calculated. The para 4, there is a step 1 which says average price to the retailer of scheduled formulation is to be calculated. And how it is calculated? Sum of prices to retailer of all the brands and generic ones. So whatever the formulations are there in schedule, the formulation of means with brands or under generic names or whatsoever you say, branded generics, etc., which have the total market turnover more than or equal to 1%, such brand, prices of such brands and generic versions of those formulations are summed or added, and it is divided by the total number of such brands which are taken into consideration. This is just simple average. For example, if there are 10 brands which are having the market share, which is calculated on the annual moving turnover of that medicine in terms of units, and the addition, the prices of those formulation is added and divided by 10. So this is simple calculation, and then this will be pricing calculation. And step 2, you have to take it forward, that ceiling price of that scheduled formulation will be calculated, that the ceiling price equal to average price to retailer, which is calculated as per step 1 earlier, that is simple average, and into 1 plus m by 100. M is margin to retailer, which is equal to 16, which is fixed. So 1 plus 16 by 100. This is a simple formula how the market-based schedule formulations price is fixed. However, the GST is not taken into consideration. The calculated price, you can add GST to it and fix the MRP. So MRP will be inclusive of all taxes. So para 6 says that, for example, if there are only 5 or less than 5 manufacturers who are having 1% or more market share, so there is likely to have a monopoly or cartelling for the price. In that condition, there are 3 scenarios by which the price is calculated. So this is also taken into consideration. So I'll not go much into detail. However, I wanted to just highlight that all types of scenarios are taken into consideration by NPPA or by DPCO in this provision. Now we'll come to how the pricing of new drug is calculated. So they have to apply in Form 1 under Schedule 2. If the drug is available in the market, then fix is as per Para 4, that is simple averaging. If not, then standing committee of experts to examine the pricing fixes these prices based on pharmacoeconomics. There are SOP for calculation or coming out with the price of new drug, and that has to be done within 30 days. So retail price will be price to retailer plus 16% margin plus GST. So Para 16 gives provision that government shall revise ceiling price as per annual wholesale price index for preceding calendar year on or before 1st April. So before 1st April, generally in the last week of March or maybe mid-March, and before last week of March, the NPPA comes out with the notification based on the wholesale price index. The revised price are notified. So whenever the scheduled formulation price is fixed, it can be reduced only during the change in the wholesale price index. And there is other power also. Government can revise this based on the, there is a paragraph, I'll come to it afterwards. The manufacturer may increase the MRP. In this scenario, whenever the wholesale price index is declared and the revised price are notified by the NPPA, what manufacturer is supposed to do? It may increase the MRP once in a year in the month of April on the basis of WPI with no prior approval of NPPA. No prior approval is required for increase in MRP based on WPI. But it is required to submit information in Form 2 within 15 days, otherwise deemed to be price violation and liable for recovery of overcharging. So it has liberty to execute the price difference, maybe increase or decrease within 15 days. They have to notify to the NPPA and then they can make changes accordingly. In case of decline in WPI, the corresponding reduction in MRP has to be done and it has to be complied within 45 days of date of notification of revised ceiling price. So if there is downward, the prices are to be reduced. The Para 31, why I am coming to Para 31? Because it is relevant to the earlier provisions. That's why I have jumped to Para 31. Any person aggrieved by notification issued or order made under paragraph 4, 5, 6, that is price fixation, ceiling price fixation, etc., may apply to the government for review within period of 30 days. So if they are aggrieved, they are not satisfied with the ceiling price notified, they have opportunity within 30 days of that notification to appeal to the government. Government may make such order on application as it deems fit proper. However, pending the decision of manufacturer shall not sell. So manufacturer will not increase the price or change the price exceeding the ceiling price or retail price fixed till the final decision is given by the government. So pending that, there is no liberty on manufacturer. He cannot change that. It can change only after revised notification, if any. So Para 19, government or NPPA has extra power in extraordinary circumstances in the public interest, fix the ceiling price or retail price of any drug. So whether it is scheduled or non-scheduled, any drug, it can fix the ceiling prices or retail price, but it should be for such period, means it should be for certain period. So whenever we see any notification issued under Para 19, it is for specific period, maybe for 1 year or so, or there is a date till which that notification is valid. We have seen these notifications during the period of COVID with respect to the prices of oxygen or whatever the sanitizers, etc. Sanitizer was not under NPPA, it was under a different department. As it may be deemed fit, where the ceiling price or retail price already fixed, government may allow increase or decrease in ceiling price of retail price, irrespective of annual wholesale price index. That's what I was saying. In extraordinary circumstances where government feels that it is necessary to revise the retail price of scheduled formulation or ceiling price of the formulation which has already fixed by NPPA, to revise it irrespective of annual wholesale price index. So it has that power. We'll see some examples about the notification issued under para 19. So anti-diabetic cardiovascular drugs wide SO dated 2014 for 108 drugs where the ceiling price was fixed, irrespective they were not under schedule. Orthopedic implant SO dated 16/8/2017. Then oncology drugs, 42 anti-cancer drugs by capping. Here the trade margin was capped. So in that extraordinary circumstances under para 19, the trade margin was sealed, fixed under this notification. Then LMO, liquid medical oxygen, oxygen inhalation gas, it was fixed up to 39/2021. 21 drugs, there was upward revision. So there was the ceiling price was revised upwardly, increased price were notified under notification dated 13/12/2019 due to maybe increase in the prices of API or input cost. So under para 20, the price monitoring is done. No manufacturer shall increase the MRP of a drug. Drug means both scheduled and non-scheduled. I mean, sorry, non-scheduled drug, not because scheduled drug price is already fixed. So you have to follow that. Here, non-scheduled drug, it should not increase more than 10% of MRP. This is very important during preceding 12 months. So here, it is not necessary that you can change in April or whatsoever. You can change anytime. However, it should not be more than 10% of the price which was existing in last 12 months. Where the increase is beyond 10%, it shall reduce it to level of 10% of 10% for next 12 months. So if I have increased the price maybe by 15%, I will have to reduce it and maintain it for next 12 months. And additionally, what that the manufacturer shall be liable to deposit the overcharged amount with interest and penalty from the date of increase in price. So very stringent mechanism has been given. Para 21, it says government shall monitor its production and availability of API contained therein, and manufacturer of scheduled formulation and their API shall furnish the information quarterly. So in Form 3, it is necessary for all the manufacturers of API as well as formulation to inform or submit the information in Form 3. Now, the price, drug withdrawal or discontinuing of drug, there is a provision under para 21(2)(b) that what is the mechanism to be followed for withdrawal of that product from the market or discontinuing that product, maybe whatsoever reason you have. Then manufacturer shall have to issue a public notice and also intimate the government in Form 4 of Schedule 2 at least 6 months prior to the intended date of discontinuation. So if I want to discontinue as a manufacturer that product, I'll have to decide many months, several months prior. So whenever I have to decide the intended date, I have to discontinue maybe after 6 months, 7 months, whatever. So at least 6 months earlier, I have to give the information to NPPA in Form 4. And within 60 days of such intimation, government may, if it feels so that in public interest that drug has to be made available, then direct the manufacturer to continue with the required level of production or import. So that manufacturer definition is both production or import or market. So it should be not be for that period not exceeding 1 year. So government may compel that manufacturer to continue the availability of that drug which is intended to be discontinued for 1 year in case of requirement of that drug in the market. So NPPA has issued the guidelines notified under on 23rd January 2017, and revised guidelines have been published. However, they are not effective right now. What procedure they have given? Procedure is public notice has to be issued in at least one English and one Hindi national newspaper. Both the newspaper you have to issue the public notice and intimate the NPPA in Form 4. So while giving the information, you have to give several other information about public notice and other details about that drug. So period to be considered from the date of publication. So your period, the period of manufacturer starts from the date of publication, which the calculations will be after that date about the availability of drug. So government will decide considering the based on the moving annual turnover in terms of unit of that drug which is to be discontinued based on the market share. So share, if it is less than 10%, it will ask to continue supply for 6 months. If 10% or up to 20%, it may ask continue supply for 9 months. And if it is more than 20% up to 40%, the manufacturer will be asked to continue supply for 12 months. And if it is more than 40%, it doesn't have power to ask the manufacturer to continue for more than 12 months as per the provisions under para earlier. However, it can invoke the provisions of para 3. So in case of emergency, they can direct the manufacturer to make that formulation available in the public interest. So implementation. So how the implementation mechanism is there under para 24, manufacturer and retailers to ensure compliance with the prices fixed or revised prices by NPPA from date of notification. Excuse me. So from the date of notification, it will be considered that price has to be effective from date, and manufacturers and retailers are required to ensure the compliance of the same. What they have to do? Issue revised or supplementary price list in Form 5 to dealers. So manufacturer, importer, marketeer is responsible to issue the price list in Form, revised price list in Form 5 to dealers, retailers, state drug controller, and government means NPPA within 15 days. They have to act within 15 days of the notification. They are required to be submit through IPDMS. This is the software of NPPA. They have to submit it through that software. Shall sell the price. Shall sell the formulation of which the price is fixed at price fixed or indicated on the label, whichever is less. So if the notification says there is a downward revision or the manufacturer's MRP of that product is higher than the notified price, it is mandatory on the part of a retailer, wholesaler, or manufacturer to sell that formulation at the price fixed, notified. And if in case it is increased, then whatever is on the label, whichever is less, it has to ensure that the product or formulation is sold at that MRP. So here the consumer's right is taken into consideration, and no ambiguity is left in the minds of the manufacturer, retailers, or even consumers also. So para 13 says schedule formulation at higher price. These are the mechanism how you have to comply. So shall revise downward to ceiling price, what I had said. So schedule formulation, if there is your MRP is higher than the notified price, you have to revise it to lower up to the ceiling price at least. Then schedule price at lower price shall maintain existing MRP. So if it is lower than ceiling price, if it is lower than notified price, you have to maintain the existing reduced MRP. You cannot increase to the ceiling price. Then scheduled formulation may increase as per wholesale price index, or shall reduce in case there is a decline in wholesale price index. Now para 28, refusal. So no manufacturer or distributor shall withhold from sale or refuse to sell to a dealer any drug without good and sufficient reason. So without good and sufficient reason, manufacturer or distributor shall not withhold, or holdings cannot be done, or refuse to sell to any dealer. No dealer shall withhold from sale or refuse to sell any drug available with him to a consumer. So direct patient, retailer cannot withhold that drug if he has the availability of that drug. He cannot say, he cannot refuse to sell to the customer. Now we'll come to non-application of DPCO, provisions of DPCO, in which case the provisions of DPCO are not applicable. So in case manufacturer is producing a patented new drug for a period of 5 years, there is exemption from the application of provisions of DPCO from the 5 years from calculated from date of commencement of its commercial marketing by the manufacturer in the country. So manufacturer producing a patented new drug, or manufacturer producing a new drug by indigenous R&D and process patented product for the same year, 5 years from the date of commercial production, commencement of commercial production, and manufacturers producing a new drug involving new drug delivery system. So new drug delivery system by indigenous R&D for a period of 5 years. So I'll just fast because it is 12:13. I'll just try to go fast. Drugs for treating orphan drug disease are decided, which are decided by Ministry of Health and Family Welfare, and there is a mechanism for giving such exemption. It is not a direct exemption. It has to go through that mechanism. Then the NPPA issues notification for such exemption. And non-compliances, if it fails to apply prior approval of prices of new drug in Form 1, sells at higher rate than retail price fixed or notified, sell at higher price than MRP. These are all violations, non-compliances of DPCO, and they are liable to deposit overcharged amount with interest and penalty, and also prosecution can also be launched, which is punishable under Section 7 of EC Act. About medical devices, there is a notification which says, issued on 31st/3/2020, all medical devices shall be governed under provisions of Drug Price Control Order 2013. And it may be noted that already 4 medical devices are part of Schedule 1, that is drug-eluting stent, bare metal stent, condoms, and intrauterine devices. These 4 are medical devices which are scheduled drugs, and other medical devices will be considered as non-scheduled formulation. So there is a monitoring mechanism by NPPA. You must be all aware of. There is a PMRU set up by NPPA in almost all states, and they are collecting the information on shortages of medicine. Data is collected from the market about drugs as well as medical devices, and they also purchase medicines and verify about the notified prices or last prices with the document. What is the action by NPPA? I'll not go much into this. So there is a standing committee which has been constituted for revision or making any changes, which is called Standing Committee on Affordable Medicines and Health Products. There are different members. So there is a forum for Pharma Association platform to discuss if there are any requirement. Then there are some proposals which are under discussion. We do not know what is the status right now. However, we may consider this, and there may be
Yes, sir.
Yeah,
It's
am I
audible,
audible?
but not very clear like earlier.
Right now, audible?
Yes, yes, sir.
So the Bureau of Pharmaceutical PSUs of India, they are asking for 20% margin on the generic drugs. The OCD is also asking for minimum 10% for wholesaler and 20% for retailers. So there are different proposals in discussion. I'll not go much into it. Just to know, because why this I have taken, because you should know what are the demands or what are the grievances which are out of coming, in spite of having so stringent mechanism of rules of paras or the DPCO, there are some issues which are there. So that's all I have. Hope there is clarity, and the provisions of DPCO were clear. We may address some questions if you want, if you have time.
Thank you so much, sir, for an elaborate and lucid presentation touching upon every minute aspects and also shattering all the myths that the entire industry or even the regulators to some extent have regarding the DPCO provisions. And you have really touched upon some of the key aspects that every pharma stakeholder should keep in mind while they're looking at these perspectives. And now we'll have some quick Q&A session in the interest of time, and I'll take a few of the important questions posed both in chat box and Q&A.
Okay.
So I believe a lot of debate is needed for some of the questions posted, and so that's first. Let me take a couple of questions given by Dr. Bardish, Dr. Jagshetty ji, that is it not a lacuna under the DPCO 13, allowing the formula out of it by changing the strength or dosage through the ingredients and use remains the same? So he would like to seek your opinion on this particular provision.
I think so. He is talking about the discrimination because of the existing manufacturer, which has been incorporated in the new drug. So there is a discrimination if the existing manufacturer is not there. If there is a new manufacturer which has come after 2013, then he is not covered under the definition of new drugs. So he may not require to seek the price approval from NPPA for new drugs. So this is a lacuna wherein the discussions which are going on there in the forum, and government also is considering this issue. So we may come out, we may see the changes also.
Sir, I presume his question is a little different, wherein just to escape from the DPCO provision, some companies tend to change the strength of the product, which is not clearly price regulated. And even we could see many such products in the market, wherein one strength, which is price controlled, is at a lower cost, whereas another strength, though the strength is lesser than the price controlled strength, is at a higher price in the market. So could you elaborate on those aspects?
Yeah, that's what. See, first thing is the scheduled formulation prices are sealed or ceiling price is notified. Now there is other scope is what the new drug, wherein price approval is required. So there is a mechanism to notify the ceiling price of new drugs. So when it will be called as new drug, the definition includes the formulation launched by the existing manufacturer. So if it is not an existing manufacturer, then he is out of that purview. However, one has to see the definition of manufacturer. So if it is marketed by a company which was existing at the day of notification of DPCO, he will be also considered as manufacturer. So one cannot say that if I am marketing a product, I have the one new manufacturer has come, so I'll start getting that product manufactured from new manufacturer, maybe 2-3 years old, and with the changed formulation, and I'll be out of that purview. No, because since I am a marketer which is already existing since and considered as existing manufacturer, I will not have that liberty. However, which company has already, incorporated now, maybe after 2013, they may think of. So that's why there is a lacuna, and you feel that there are different prices of different drugs, and there is huge difference. So this is there.
Certainly, this question answers another question posed by Mr. Ramesh Jain on this aspect. He is specifically touching upon those firms which have established after the 15th May 2013 and coming up with a new formulation, and whereas existing manufacturers are in a position of a losing state in changing the formulation and all. I think the elaboration you have given is clearly answered the question from Mr. Ramesh Jain. And so I'm taking another question, sir, wherein so whether NPPA monitors the availability and shortage of the medicines in all the states? If so, are the actual officers and are they notified under NPPA? So can you just elaborate on how the NPPA is monitoring these issues of the availability and shortage of the medicines, though we have provisions in place?
You're talking about the notification. See, the notification officers are to be notified by the state government under Essential Commodities Act, and there can be a notification also under DPCO. So they will have to issue new notification after every DPCO is notified. So there is a notification of DPCO 1995. There should be again the notification of DPCO 2013. So state government has to issue that so and so officers are empowered under that EC Act or under to enforce the provisions under DPCO 2013. So this is necessary.
Sir, regarding the monitoring of the availability or the shortage of the medicines, though NPPA has provisions to monitor these conditions, but in the ground reality, like whosoever is, like who are the actual persons monitoring this availability? So this is what the question I could.
So NPPA has devised the mechanism. So it may require improvement in that mechanism also. But they have IPDMS, wherein the information about the manufacturing, production, distribution, availability has to be submitted under IPDMS. as well as they have set the PMRUs in all states. Their job is to see into market about the price violation as well as the availability of the drugs. In addition to that, if there is shortage, even drug inspectors get the feedback about shortages. The state drug controllers, they can also take up the matter with the NPPA. So this is the mechanism through which the NPPA can exercise its powers to ensure the availability of drugs.
Thank you, sir. Sir, there is another question which stuck in my mind since the formulations obviously depend. The price of the formulations depends on the price of the APIs, and in the current scenario where we depend a lot on the APIs from other countries, and there is a huge price fluctuations of the APIs, and even the industries are so much worrying about the price fluctuations of APIs, which in turn affect their formulation prices, which are under price control. So, in your opinion, what is your thoughts on the linkage or even the price control mechanism under the current uncertain cases of the price fluctuations of the APIs?
Yeah, see, the NPPA has power to revise the prices, ceiling prices, and NPPA has to be informed. See, manufacturers are not so vigilant, or some of them are there. They take up the matter immediately because there is a 15 days or 30 days period within which they have to approach NPPA for any grievance regarding the ceiling price notified. So within that period, they have to approach NPPA. So there might be a gap in that, and NPPA has revised upward revision. They have notified few prices due to this upward higher prices of API or input cost. So there is a mechanism. However, the connection or the vigilance of the manufacturers or stakeholders should be there. They should immediately take up the matter and submit the evidences about the input costs and get or request the government to consider the notified price.
Lakshmi,
Yes, sir, please.
I have some points with respect to the consumer point of view. So recent about upward revision of prices by the NPPA have increased furor in the market, the public anger, that 10% annual increase with the based on the WPI. So is it some public experts have opined and argued that WPI is dependent on the on price rise in the basket of range of goods that are not directly linked with the items that go into the cost into calculations. So demand for unrealistic, simple average method of calculating ceiling price should be replaced by cost plus mechanism that was prevalent in 1995 DPCO. So if we consider our status in India, particularly in the public health expenditure, you will agree that that people of a large number of people still not up to the mark in case of fulfilling the healthcare needs. Coverage of health insurance is limited, and most of the peoples are engaged in informal honorary sectors and with no social security. So affordability and related issues are among the most vital point for the vast majority of the population. So what is your opinion that if you are seeing the slide, comparing the slide 1995 DPCO and 2013 DPCO, so which one is the best formula for the benefits, the price benefits to the pass to the consumers? What is your opinion, please?
Actually, there are different scenarios. This is not the only method. Earlier, it was there, input cost based. However, this was also not revised from time to time. And in this scenario, where the input cost has increased in many folds, the API cost has increased many folds. In this case, the effect of price increase would have been very much, not only 10%, as compared to WPI. So this would have been increased in many folds, maybe twice or thrice, if the input cost would have been considered. In that case, the hue and cry from the consumers would have been more. This provision is already there. Every year the NPPA is notifying the WPI and revised price. Earlier it was 1.7%, 2%, etc. Last year it has come up to almost 11% or 10.7%. So that's why it has been visible. This price rise has been noticed by everybody. But if you talk of other things, for example, if there is an inflation, if there is a price rise across, only the criteria must have, basket of items must have been chosen. There might be a logic. However, the impact on the pricing is already there. And if you talk about the non-scheduled formulation, they are allowed to raise the price not more than 10%. But the WPI, which is more than 10%, so they have to absorb the cost which is already raised by WPI, which has been impacted by WPI. So that is also higher impact on the manufacturer. So that also has to be considered. However, government is under discussion. It can change through the new policy, and there is a consensus on, the consumer forums have also asked to fix the trade margins. So government might come up with the revised DPCO or revised mechanism also, wherein why this is visible, why people feel, because there is a lot of difference in the prices of similar formulations in the market. So why it is so? Because there is change in trade margin. So somewhere there is ethical marketing, somewhere there is the propaganda kind of marketing, and there the trade margins are very high. So these all aspects have to be taken into consideration by the government. And if the consumer forums and the manufacturer stakeholders deliberate with government, they may come out with the good solution also.
Actually, Niti Aayog also considering this aspect. So far as I learned,
Yeah.
the data from the NPPA submitted by to the standing committee, that I like to share that more than 18,000 crores overcharge amount that to be realized by the NPPA. So the many companies are the defaulters.
Yeah.
So in the 2020 and 21. So there is a chance to revisit the scenario, the charging of ceiling price and framing of cost-based price and that things. That because most of the people cannot afford that price of medicines because of the poor scenario in our, particularly India. Okay, so in our country so many people are living in the below poverty line. So I think cost-based formula should be replaced by the actual cost-based formula should be the befitting one.
You're right, but then still
earlier it was a MAP value, maximum allowable.
Right. However, the accessibility or making medicines available at lowest price is not only due to ceiling prices, fixing prices. It may be considered or making available through the government procure agencies also, that can at subsidized prices or maybe through insurances, etc. It has to be visited through different approaches, not only fixing the prices, not only through DPCO.
Okay.
I guess a lot of discussions needed on this subject from different perspective, and even I could see many comments from the senior most officers. Mr. Unnikrishnan Panikar is there in the group, and of course a lot of even thought process by Jag Shetty and even Kaushik Desai ji's comments also I could see, the Secretary General of IPEC. But in the interest of time, Can we take a couple of questions, sir, if it is convenient for you? Otherwise, we can discuss.
Yeah, we can take, no issue.
I'll quickly take a couple of questions, sir. So Kaushik Desai is offering some of the comments, and I'll just pick up the questions shared by him. So he is touching upon the frequency of the revision of the prices. In the recent days, there is a frequent revision of the prices by NPPA for the same formulation, and which has become a major hindrance for the manufacturers, especially wherein they have to again go for the labeling changes and even the changes in the stock in the market. So the suggestion, can't we extend a suggestion of fixing up a schedule, the standard schedule for revision of the product, of the prices, rather than a random revision? So this is one of the suggestion. And another point is that and also when they are making announcement, so the price revision, whether it is on a higher side or a lower side on the existing price, is also not clearly indicated. So the suggestion would be like, if they clearly indicate what is the revision, whether it's an upward or downward revision, that is also a suggestion. That,
yeah, so it is difficult if we talk about the notification which is effective from the date of publication in the Gazette. It is difficult to implement for a manufacturer because there are a lot many things which have to be done simultaneously, and it is difficult to give effect within a small period of time, maybe 15 days, 30 days or so. So if it is, there is a clear-cut provision and mechanism given about the implementation of the decisions by NPPA, this would be guidance for, or this would help the industry as well.
And so another question from Unikrishnan Panikanji, the former president of Adcock, is that what about the chemist exhibiting boards awarding excessive discounts? Will there be any, are there any provisions in the DPCO to mitigate these kind of a branding promotion or the promotional activities by the companies or the retailers in terms of extravagant the discounts to attract the customers?
The object of the NPP pharmaceutical policy or the DPCO is to make available the medicines at affordable or lowest possible cost. So if they are being available at more lowest cost or affordable cost, this is in the interest of public, I think so. So this may not be objectionable. Only thing is that this may impact the businesses. However, the impact on business, they have to change the strategy, etc. But this might be inevitable due to maybe online platforms, etc., or more number of outlets, more number of brick and mortar chemists have come out. So this can be addressed through other, not through DPCO.
So can you quickly touch upon the price revisions for a cosmetics by a company? So this is one of,
actually, cosmetic is not under the purview of DPCO. Only drug has been notified as an essential commodity, not a cosmetic. So based on the essentiality, it has been notified. So cosmetic is out of purview.
Sure, sir. I think we have touched base with the important questions, and in the interest of the time, I would be winding up the Q&A session, and I would like to invite brief comments by our honorary DG, Mr. Uday Bhaskar. You're on mute, sir.
Hello.
Yes, sir. You're audible.
I'm not aware of that. I'm supposed to pass any comments. So whatever it may be, I heard Jayanta. So I totally endorse what Jayanta says. Whatever policies you have formed, it should be consumer friendly. But the pricing system, how they arrived from the old system, is pro-industry. Here, industry is not happy, and at the same time, the consumer is not happy. So we should come up with a system which should balance both. That's That's what I feel.
That's a key takeaway from the entire session, sir. And even as you said, industry is, I mean, we could very often hear the comments from the industry that because of the DPCO, some of the products got killed and they're not available or withdrew from the market, which are very much useful for the certain therapies and all. So there are too many things that the policymakers or the mechanism involved in fixing up the prices need to be taken care in the system. And now, may I invite Dr. Dharmadatta sir for the concluding remarks, please? Dharmadatta sir, are you there? Oh, seems he is off call.
Yes.
Hello?
Yeah, hello.
Yes. Anyway, at the outset, this presentation is very nice. Nilesh Gandhi, congratulations. You have touched the important points where drug inspectors, usually in the field officers, will get in doubts, and those things are very clearly done. And yes, this is a good presentation. DPCO, it is a big subject. Every time it is a new law. Every DPC is a new law. That is why in the coming, already 9 years are over, 30 to now 22. So another DPC may come. In that, I think the government will incorporate certain things that we are feeling now. We incorporated, then the public will be more benefited with that. Definitely, there are some loopholes, and I think something should be plugged in now because of our experience. That will hope that new policy will come and fulfill it in the next DPCO. It is coming, I think, very fast, I think, in future. Thank you very much. Congratulations for a very nice presentation.
Thank you. Thank you so much, sir. And our special thanks to Nilesh Gandhi, sir, for such a wonderful and insightful presentation. Within a short notice, I could say less than a week, and really appreciate your efforts. And our sincere thanks to Dharmadatta sir for your presence and for your valuable guidance and address in this August gathering. And my sincere thanks to President Jayanta sir and DG Uday Bhaskar and all the participants, and especially all the senior officers who have been actively joining the webinars. I could see a lot of senior ADCOG members, joining every webinar without fail. It really shows the enthusiasm that the officers are keen to learn the recent updates, and it shows their affinity or the close association to the ADCOG activities and the support to our initiative. Really appreciate your time, sir, and thank you once again. And with that, I wind up this today's session.
Thank you.
Thank you, Gandhi. Thank you very much.
And thanks a lot for giving me the platform to interact with all of our old colleagues, stalwarts, and thanks for giving me opportunity. Thank you.
Thank you all. Thank you, one and all.
Thank you, Lakshmi, for nice presentation, nice coordination.
Jayanta, thank you so much.
Thank you, sir.